represented the Better Government Association, other organizations, and many individual citizens in dozens of Freedom of Information Act cases over the past few years. And I'm going to talk to you today about the Illinois Freedom of Information Act. Lay of the land, what is FOIA? Nuts and bolts, teach me how to FOIA, and I've been denied, now what? Before we begin the presentation, there's a few disclaimers that I'll need to give you, being a lawyer. The views expressed in this presentation are solely those of the presenter, me, and should not be attributed to the presenter's firm or clients. This presentation does not constitute legal advice, nor does it constitute solicitation of an attorney-client relationship. Finally, FOIA law is very fact-specific and constantly evolving. This presentation provides only a basic and general overview. So let's start with the lay of the land. What is FOIA? The key language to understanding or beginning to understand FOIA is the following. Each public body shall make available to any person for inspection or copying all public records except as otherwise provided in Section 7 of this Act. And we're going to unpack each component of that so we can start to get an understanding of how the statute works. First, each public body shall make available. Well, what is a public body? Section 2A of the statute defines a public body, and it includes such things as the state of Illinois, legislative bodies, counties, cities, and towns, school districts, police departments, and other such departments and districts, and then boards, departments, commissions, etc., of any of those bodies. So a department of the state of Illinois, a commission of the state of Illinois, a board of a particular municipality. These are all public bodies under the statute. Courts are not subject to FOIA, but are subject to other laws that pertain to open courts. Also, federal agencies are subject to federal FOIA, not Illinois FOIA. And while the statutes are similar, there are a lot of differences as well. So we'll be talking today about the Illinois FOIA. And for example, if you had a FOIA request to the federal post office branch in the state of Illinois, that would be a request subject to the federal FOIA and not to the Illinois FOIA. A little more on public bodies. Nonprofits, public-private partnerships, things of that nature can become a little bit complicated. Generally speaking, public funding alone is not enough to make a nonprofit or public-private partnership or other such entity a public body under the statute. And that includes even if 100% of the funding is provided by a public body or by tax dollars. Instead, the factors that are relevant to consider are whether the entity has an independent legal existence. For example, has it been incorporated as a separate nonprofit organization? The nature and functions performed by the entity, are these governmental type functions or are they something more typically done in the private sector? And three, the degree of government control exercised over the entity, which must be substantial day-to-day supervision, not simply generalized involvement. So that defines, in general terms, what constitutes a public body under the statute. The next question is, what are public records under the statute? Well, Section 2C of the statute provides a definition for public records, and it's very broad. It includes things like reports, forms, writings, letters, memos, emails, contracts, basically any document, regardless of form or characteristic, would be a public record under the statute, subject to a few items I'll discuss in a second. This includes electronic records of data, and a requester can request electronic data in a particular specific format, and it must be provided in that format if it's feasible to do so. If it's not feasible for the public body to do so, then the requester can choose between the format in which the document or data is kept in the ordinary course of business or in paper format at the option of the requester. Finally, public records are subject to the Act if they pertain to the transaction of public business, if they were prepared by or for, or have been used by, received by, in the possession of, or under the control of a public body, which is a pretty broad definition of what types of records that a public body has would be subject to the Act. A few more points on what constitutes a public record. There's no FOIA obligation to create any documents or answer any questions. Rather, the statute applies to documents that currently exist that are within the possession, etc., of a public body. There are other laws that may require particular documents to be created or maintained, but those go beyond the statute, the FOIA statute itself. There are certain items that do have to be maintained or created under the FOIA statute, and those are the following. A brief description of the public body, block diagram, total operating budget, number and locations of offices, the approximate number of full and part-time employees, membership of any boards, councils, etc. That type of information must be made available, must be maintained and made available under the statute, and must be posted on the website if the public body has one. Also, a list of documents or categories of records that the public body shall immediately disclose upon request. This may be items such as budgets or other commonly requested items. A reasonably current and detailed list of all types or categories of documents under the public body's control. The idea is to give the public something of a starting point to understand what kind of documents the public body has and how they're maintained and how they could be requested. Also, copies of all notices of denial of any FOIA request, indexed according to the type of exemption asserted and, to the extent feasible, according to the types of records available. There are also other items under the Open Meetings Act and other laws that are required to be kept and maintained under the statute. So all of these items can be very useful tools as you do a FOIA request. For example, if your request pertains to some particular issue, it may be helpful to request some of this additional information to help you get a better understanding of what else might be available. So now that we've discussed who is a public body and what records are public records, let's talk about some of the exemptions. Section 7 and 7.5 of the statute lists out a number of exemptions that a public body can assert over a public record. And with only one exception, these are at the option of the public body. A public body is not required to assert most of these exemptions if they apply, but can elect to do so if it wishes to do so. In addition, it's important to keep in mind that some documents may have some material that's exempt and other material that isn't. The statute makes clear that the public body may elect to redact the information that is exempt, but must produce the remaining information. So let's talk about some of the common exemptions that are claimed. One common exemption is called personal privacy, and that exemption applies to information that would constitute a clearly unwarranted invasion of personal privacy. But there's more to the analysis than just that. It must be information that is highly personal or objectionable to a reasonable person, and in which the subject's right to privacy outweighs any legitimate public interest in obtaining the information. So let's unpack that a little bit. It must be highly personal to a reasonable person, and that personal or objectionable nature must outweigh any legitimate public interest in obtaining the information. So this will be a highly fact-specific analysis that will depend on exactly what the information is that's been requested and what the potential personal privacy right is. In addition, and very importantly, the disclosure of information that bears on the public duties of public employees and officials shall not be considered an invasion of personal privacy. You may have a request that may seek information about potential wrongdoing by a public official. It may be things that are highly personal, but if they relate to the public duties of that employee or official, then notwithstanding any privacy interest or privacy issues, the document would still need to be produced. Let's turn next to private information. Private information is different from personal privacy. It is defined in Section 2C5 of the statute. It includes things like social security numbers, home addresses and phone numbers, and things of that nature, which are very specifically defined in Section 2C-5. Another common exemption applies to drafts and internal memos. This is sometimes called the deliberative process exemption or the preliminary drafts exemption. The document need not necessarily be a draft to be subject to the exemption. But it only applies where opinions have been expressed, and it must be pre-decisional. In other words, the deliberative process in which a public body is attempting to reach a decision and opinions are being expressed in furtherance of that. That is to what the exemption would apply potentially, but it does not apply when the record is publicly cited and identified by the head of the public body. So if we're talking about a municipality and the mayor speaks at a some sort of public hearing or in the media or anything of that nature about a study that had been done connected to some decision that had been made, then the exemption would no longer apply at that point. Another common exemption is undue burden. It's actually found in a different section of the statute than Section 7, which contains most of the exemptions, but it does come up fairly frequently. It applies only to a categorical request. So for example, all documents related to blank. Requests of that nature could potentially be subject to the undue burden exemption. The public body must work with you to try to narrow the request. So if you've made a request for all documents related to a particular property, and the public body responds that that would be unduly burdensome because it would require the review of tens of thousands of documents, the public body cannot simply deny the request, but must tell you that they are asserting that exemption and then engage in a discussion and negotiation with you to try to narrow the request to something that is more manageable. And we'll talk later in the nuts and bolts section about different ways that you can accomplish that goal. And a very important thing to remember about the undue burden exemption is that if the exemption is not asserted within the 5-day requirement, which we'll talk about in a little bit, in other words, if the response was untimely, then it's waived. So if 5 days go by and you did not receive a response to your FOIA request, and on day 8 you receive a response that asserts the undue burden exemption, that claim is faulty under the Act because the response was not timely, such that the undue burden exemption was waived by the public body. Proposals and bids are another common area of exemption. So proposals and bids, a request for proposal process or something like that, those proposals and bids are subject to an exemption, but only one, if disclosure would frustrate procurement or give an advantage to any bidder, and two, only until an award or a final selection has been made. Once that final selection has been made, then the bids are no longer exempt. Law enforcement and administrative enforcement records are a common area of exemption, but they're limited to documents that are created in the course of such proceedings. Not simply related to, but created in the course of such proceedings, but only to the extent that disclosure would interfere with proceedings, deprive someone of due process, disclose confidential informants, or disclose unique police or other techniques where disclosure would result in a demonstrable harm to agency or safety of any person. I've provided for you some of the more common exemptions, but it's important to note that there are many others under the statute. A very important thing to keep in mind if you receive a rejection based on an exemption is to look up the exemption and read it very carefully. Because as we've seen in discussing some of the more common exemptions, there's a lot of language along the lines of only if or but only to the extent. And it's very important if you receive a denial to make sure the public body has provided you with an explanation that addresses all of the only ifs and all of the but only to the extent language. So for example, if you received a rejection based on the law enforcement exemption, you would want to take a close look at those additional requirements created in the course of such proceedings, but only to the extent disclosure would, etc. And if you haven't been provided an explanation that addresses those issues, that's something that you will likely want to address with the public body. Let's turn now to the inspection and copying part of the statute. Can they charge me for copying is a common question. The statute allows for charges of up to 15 cents per page of black and white copy, with the first 50 pages free. A common technique that we use is to request the documents in electronic format, or if they're paper documents, to ask the public body to scan them and send them as a PDF. This allows you to avoid the potential for copying charges, and at most, if you wanted the documents by disk instead of by email, the public body could charge you for the cost of the disk only. You should keep in mind that the statute allows for a waiver or reduction of copying charges if you state the specific purpose for your request, which must be to access and disseminate information regarding the health, safety, and welfare, or the legal rights of the general public. And if you believe that applies to your request, you should include that language in your request and ask for a fee waiver if you want the documents in archive. Otherwise, I generally advise people to request the documents to be scanned and emailed as the most convenient and cost-effective way to obtain the documents. You can also also ask for an inspection of files. Particularly if what you wish to inspect is a large volume, you might want to consider going down that approach. Or if you're not exactly sure what it is that you're looking for and just want to get a feel for the kinds of documents related to an issue. Generally speaking, you cannot simply show up at a public body's office and ask to inspect the files. You'll have to schedule a time to come in to do the review, and the public body may elect to review the documents first to determine whether any documents are subject to an exemption. Finally, no fees can be charged to you for the search time or other personnel time involved in responding to your request, unless your request is a commercial request. The term commercial request is defined in Section 2C10 in the front of the statute and is very particular and pertains only to very specific situations.